Thank you very much, Chair. So by way of introduction, my name is Nalini Singh, and I am the Executive Director for the Fiji Women's Rights Movement, and I have with me Shayal Nand, who is our team leader for the Gender and Transitional Justice Program. Thank you so much for inviting us to present our, the key issues that we have. In introducing the Fiji Women's Rights Movement, or FWRM, as we are commonly known as, we are a feminist organization committed to removing all forms of discrimination against women and girls through advocacy, research, and legislative reform. FWRM recognizes the importance for women and their rights to be protected in the workforce. We advocate for gender equality and the protection of women's rights in all sectors, including decent work to ensure that women are treated fairly with protections that promote their full participation and development in the workforce. We appreciate the opportunity to make this submission to the Employment Relations Amendment Bill 2025. And from our experience and in the areas of work, we would like to focus our submission on 7 key issues. The first being sexual harassment in the workplace. Second, around the maternity leave provisions. Third is on paternity leave provisions, which is not included, but we'd like to bring that up. Fourth is protection of pregnant and nursing mothers. Fifth is gestation and legal abortion provisions. 6 is menopause and menstruation in the workplace. And 7 is child labor provisions. So focusing on the first issue, sexual harassment in the workplace, this is section 76 on page 28. Sexual harassment in the workplace remains underreported and not widely recognized as a serious problem. 20% of women on average face sexual harassment in the workplace, with incidence of being the highest, 35% for those in the hotel and accommodation industry. 82% of sexual harassment cases in Fiji go underreported. Such data indicates the urgent need for all organizations to have a proper sexual harassment policy. FWRM, we acknowledge Section 76 of the proposed bill, and we say that provisions for heavy fines, which that section is all about, and penalties against employers and employees for incidents of sexual harassment in the workplace is critical. It reinforces accountability and a zero-tolerance stance to the offense. In the last several years, FWRM has conducted 21 sexual harassment or stop sexual harassment in the workplace training with different organizations, and we have found that employers refuse to act on complaints of sexual harassment because of a lack of understanding of the offense and or for fear of reputational damage and biasness. In addition to the proposed fines and penalties for the offense, FWRM recommends that employers must strengthen their sexual harassment in the workplace policies to include immediate action as the matter is reported. Strengthening sexual harassment policies to include immediate action when a matter is reported is crucial for creating a safe and respectful workplace. Immediate responses help to show that the organization takes the issue seriously and is committed to addressing concerns promptly. Clear steps for reporting, investigating, and addressing complaints are necessary to prevent harm and protect both employees and the organizations. FWRM re-emphasizes the employer's duty of care and responsibility to provide a safe workplace for all employees and to be proactive in addressing all forms of sexual harassment in the workplace. Furthermore, Section 76 also mentions the fines and penalties imposed on both employers and employees who commit sexual harassment incidents that involve children who are accompanying their parents to work, and that is welcomed, as it ensures that children are in safe environments. Our second issue of concern is around maternity leave provisions, and that's Part 9, Section 101 to 104, beginning on page 62. Paid maternity leave is critical because it protects the physical, mental, psychological health and well-being of a woman and her child at prenatal and postnatal stages. We acknowledge that the bill provides that in the section 104 at 3A, that every 3-month interval from the expiry of a maternity leave, the employer may elect to refer the woman to an independent and registered medical practitioner for an assessment on her fitness to work. So here, the duty of care is on the employer to ensure that employees returning to work after taking maternity leave are in good health. Women experience postpartum illness and depression after childbirth in many different ways, and often it remains underreported. If untreated, studies show that women can experience postpartum symptoms even as late as 9 to 10 months after childbirth. In Fiji, postpartum depression affects about 10 to 15% of postbirths annually. So FWRM welcomes the inclusion of this section, but strongly recommends that it be further strengthened by noting the following policy justifications: that the independent and registered medical practitioner is specialized, and from the obstetricians and family physicians in this case are mentioned. Obstetricians have additional skills and training in women's health and in caring for mothers and babies during pregnancy and after birth in the communities, and that the process and outcome of the assessment is confidential and non-discriminatory. Such medical assessments can be stressful, therefore it would be advisable that proper referrals are done to ensure the safety and well-being of the women is paramount. Our third issue is around paternal maternity provisions. We do note that the draft Employment Relations Amendment Bill still does not accommodate for paternity leave. FWRM stands firm in bringing paternity leave back to promote gender equality so that it will balance caregiving responsibilities, further reducing the burden on mothers on unpaid care work burden. Childcare is both parents' responsibility. In Fiji, women do 73% of the unpaid care household work, as well as the communal unpaid care work as well, as compared to 27% by males. Women spend 4 to 6 hours more to juggle housework even after work hours. Childbirth and rearing can be a challenging time for mothers, and having fathers sharing caregiving responsibilities would not only ease the burden of unpaid care work for women, but also provide the much needed emotional support to mothers, easing postpartum period for the mothers, thereby promoting better mental health and well-being. We have to be very mindful not to discriminate against other types of family unions as well, which will have children. Same-sex couples, couples who adopt children must get the same paternity entitlements for child bonding, love, and trust building. Our fourth issue is around the protection of pregnant and nursing mothers, and this is part 9, page 61. Many countries include specific provisions in employment laws that protect employees that are pregnant or nursing because of the work environment, which means workloads, type of business, demand, stress, etc. And duty of care rests with an employer to ensure that risks are minimized to the pregnant or the nursing women. FWRM welcomes the inclusion of specific provisions that cover women that work while being pregnant and nursing, which reads as no employer shall compel a pregnant or a breastfeeding woman to perform work which may harm the health of the woman or her child. An employer who breaches subsection 1 contravenes this act and is liable for sets of fines. We draw attention to section 101C1, which reads, a woman who returns to her workplace after maternity leave is entitled to at least one paid daily break, if not more than 30 minutes, in addition to other breaks, and access to facilities to breastfeed where practicable and nurse her child or express milk of up to 3 months. In 2012, Fiji ratified the ILO Maternity Protection Convention, number 183, which safeguards a woman's right to breastfeed her child or take reduced working hours to allow for breastfeeding. The convention is legally binding for the countries that ratified it. In the convention, it states the following requirements. A. That a woman has the right to one or more daily breaks or a daily reduction of working hours to breastfeed her child. B. That the nursing breaks or reduction of hours be counted as working time and remunerated. And C. That provisions are made for the establishment of nursing facilities near or at the workplace for breastfeeding mothers. FWRM recommends that a review of the time allocated to nursing mothers is needed. It would take a woman more than 10 minutes to travel home or to a location where the child is being looked after to breastfeed the baby. In some instances, women find it difficult to breastfeed their child when under pressure, stressed, or due to health-related issues. These factors can cut into the allocated time stipulated in Section 101C1, which makes it unreasonable for women. Also, most workplaces in Fiji do not have facilities to accommodate women who need space to express and store breast milk for later use. Additionally, FWRM requests that Section 101C include Article 10.2, which protects remuneration for the time taken for nursing mothers to breastfeed their child. And lastly, that the proposed bill includes paragraph 9, which makes provisions for the establishment of nursing facilities near or at the workplace for breastfeeding mothers. Our fifth issue is gestation and legal abortion provisions, and that's Section 101 on page 32. We have reviewed and we welcome the provisions under this section, which provides sick and or compassionate leave for women who have given birth and have experienced a miscarriage or had a legal abortion. Our sixth issue is around menopause and menstruation in the workplace, Section 68 on page 60. Workplaces in Fiji, or most workplaces in Fiji, are not designed to support women when they menstruate. And that includes either paid breaks, flexibility at work, time off, fans, proper changing rooms with shower facilities, menstrual products, and other menstrual accommodations. These access gaps may lead to low productivity and discomfort at work. We note Section 68, 1A, which reads as, a woman may use 3 of a 10 days sick leave if she has severe or debilitating menstruation. We recommend that the proposed bill includes provisions that provide reasonable accommodation for women so that they can menstruate at work with dignity. These can include, but not limited to, A, paid break time, B, bathroom facilities that include showers, uniform changing options, hot water bags, menstrual products, etc. And C, options to leave work early due to heavy flow or cramps. Furthermore, FWRM proposes that there is a distinct separation between sick leave and menstruation leave. Women go through menstruation every month, and some being twice a month, and it affects women differently. Some women experience symptoms such as bloating, headaches, and cravings, while others experience severe pain and bleeding during their menstruation and experience physical discomfort, weakness, and cramps. FWRM suggests the following. A, that there is a distinct separation between sick leave and menstruation leave. Having separate menstruation leave allows menstruating women's needs, such as rest, to be recognized without using up sick days that might be needed for other health issues. B, that women be allocated 12 days paid menstruation leave because we bleed every month. Additionally, menopause is a natural stage of life for women, but the symptoms can cause early retirement and even a change in career path for women. Some symptoms include entirely hot flushes, memory and concentration difficulties, mental health issues, insomnia, etc. Research studies done in this area reveal that many women experience menopause at work but do not feel comfortable to communicate this with their managers. This is an opportune time for the proposed bill to include reasonable accommodation for women during their menopause period that include paid menopausal leave as well. And our final issue is on child labor provisions, which is Part 6, Section 90 to Section 98. Child labor is a violation of human rights against children and is protected under ILO Convention number 138 on minimum age and Convention number 182 on worst forms of child labor. Determining the minimum agreed age and specific categories of employment need to be included in the regulations. It is crucial to ensure protection of children from child labor and exploitation. Additionally, specific categories can help define what is considered acceptable and unacceptable in terms of child labor, reducing the potential for abuse and exploitation and unsafe work environments. ILO Convention 138 makes the following conditions. A child may be employed at the age of 15. A child may be temporarily employed at the age of 14 for countries where there is underdevelopment. And a child may be employed at the age of 18 in instances where the type of work may likely impede on the child's health, safety, or morals. FWRM requests that the proposed bill outline the specific categories under the convention so that children being employed are protected. Additionally, we request that Section 98 include the different types of work, which includes industry, whether it's armed forces, hospitality, etc., to protect children from being exploited. So these were our 7 issues and our recommendations, Chair.
Making your submission. Now I open the floor for the honorable members. If you have any questions to ask, you may do so now. Just to get the ball rolling, we have gone around the country for consultation. We've met various stakeholders. We've met women's group and many more. There were some concerns expressed by women that with all this provision, they feel that the employers will not choose or select women to work or give them employment. What's your thoughts on that?
Thank you for that question, Chair. And that's exactly our point when we advocate for gender equality and work towards removing the existing biases that exist, that are, in terms of, in the foundations of our society. So we have to move away from taking that, it's going to be too expensive to employ women, or, there's too many leave provisions, and usually it's cost related, so it's more expensive to employ women, for the time they would be giving in. But if we believe that we are a modern society, we recognize women as having skills and capabilities to do any type of work that they would like to do, match their education and qualifications, then we have to be prepared to also understand that biologically women are different. Yeah, and that cannot be used as a point of discrimination. And Fiji, as a member of the United Nations, we have signed on to the convention to remove all forms of discrimination. So when we get into a situation of where there is non-compliance with that, then we are against that international law, and we are moving backwards then. So providing for specific leave for women because their biology demands that, to me, is not regression. it is being very progressive and positive and understanding of the fact that women are equal contributors. However, they are the only sex that will require a little bit more because they are the only ones that will fall pregnant and give birth. And if we want the society to continue, and we also want women to become equal contributors to that progress in society, then we have to recognize it and provide provisions. Now, there's also a claim that such leave will be abused. Every type of benefit that is provided, there is some likelihood of being abused. So it falls on to employers and those of us who run organizations to put in procedural mechanisms, build in understanding of what happens if we abuse certain benefits and entitlements, and work towards everyone understanding what the leaves are for and having a gradual move towards compliance. We don't see 100% abuse of all the benefits. Yeah, but there will be some who will. So how do we work that out? To me, providing certain provisions that cater for women is not regressive, and it will in the long run balance out and pay out in rewards for employers as well.
Any other question from the honourable members?
Thank you, Chair.
Honourable Ali Pate, you want to ask a question?
Yeah, after Honorable Korla.
All right, thank you.
Thank you, Chair. I just wanted to work out a balance. If you look at maternity and then you look at menstrual leave, at the moment the total leave is around about 30 days. If we look at menstrual, it'll be a monthly leave. What is your proposal if there's, and then you have paternity leave again. What is your suggestion if there's consideration for menstrual leave? Considering that after birth, there's already an allocation of 3, 6, and there's some discussions on extension of another 3, which is 9 months. If we were to consider the especially for menstrual, what is your suggestion?
We are saying 12 days because periods, they are monthly. And each woman experiences it differently. Not that all women will be going on, and taking that leave. Is those who need it, because we know of women who experience severe pain. Yeah, and it's not counted as an illness because it's not an illness. It's a natural occurrence, cramps, bloating, aches and pains in joints and all of that. And with menopause, it's worse. It's really, unbearable in terms of what happens to women. And having some sensitivity displayed by employers is going to not only build, confidence in the work that is being done, but it will show that, that the employee is being valued, right? So for us, we are saying, put in the provision of at least 12 for those that go through that, severe symptoms of menstruation and menopause as well. But, it's not mandatory that all women will be taking that leave. The provisions are provided because it shows the duty of care. That we are recognizing that, some women will go through severe pain and will need to take some time off. So to me, it's only fair that there is some recognition of that, and to have it for 12 days because it's a monthly occurrence. For maternity leave is different. Maternity leave is for recovery, care of the child, etc. And paternity leave, when put in this application, is for the father to be, or that figure to be providing support to the mother who is, recovering through postpartum, looking after the child, and all of that. Working out and contributing to, she might still have the unpaid care burden even after giving birth. So all of that, to me, in a modern society that we are, and the fact that we are looking at workplaces that cater for workers' rights, I think that's a step in the right direction. 3 days to me, it's not fair because we don't menstruate, only 3 months. It's every month.
Honorable Alipate, over to you.
Yeah, through you, Madam Chair. This is regarding to the sexual harassment in workplaces. Um, what's your view on some workers who may report sexual harassment, and some who may entertain or comfortable with the same type of sexual harassment?
So, Chair, that's an issue that we have found in our own research and advocacy. That one of the biggest barriers is not knowing what sexual harassment is. So we have taken up in our training programs to make that one of the first things we do is have an equal understanding of what does Fiji's law say in relation to what sexual harassment is, and that's a gap. And in our case in Fiji, we have a unique application as well in terms of culture, because there are some cultural relationships where in the workplace certain jokes can go a little bit too far, and that's when sometimes women, often because women are the larger proportion of victim survivors, they don't know how to treat that, and would let that slide, and sometimes it goes a little bit too far. However, our laws are very clear around it, and so having widespread training is very important, and all employers as well as employees need to understand what are the different types of activities that can cause sexual harassment cases to be lodged, and that ranges from physical, verbal, even visual. So it's not just physical. The definition is quite broad, and we find that many are not aware about that, and that kind of awareness trainings and having organizations proper protocols and procedures in place, then it builds confidence for women to report such cases and have a safer work environment.
Any other question? Follow-up question from you, Honorable Alipate? Is there any follow-up
That's
question?
all.
All right.
That's all, Madam.
All right. Thank you. Honorable members, any other question from you?
Thank you, Chair. I just wanted to work out a balance in trying to work out, especially when you look at men's and also maternity. If you are considering men's as a day for each month, which will total up to 12 days, would your organization consider reducing annual leave to accommodate some of that as part of an additional sick leave? Would you consider balancing that if that is a consideration?
No, they wouldn't be, because, as I said earlier, menstruation is not an illness. And for women, their symptoms or what they go through can be very varied. So 1 month I could have no pain, no issues, but the next month, it could have an extremely painful period. So knowing that I have something out there to that allows me to take rest, because I'm not sick and I'm going through a normal occurrence, gives me comfort to know that I can take, a day off and, rest in bed, and make sure that I am well and, much better in terms of my mental health and physical health and contribute to work. So no, I would not consider reduction in sick leave, compared to menstruation leave. And in my own organization, we have allowances for anyone, any woman who would want to take a day off. So ad hocly we do. I mean, especially in the women's movement, we are cognizant of what happens to women. But it'd be great to have that. Officially provided in our laws. I know 12 days may sound a lot and employers will object to it. But 3 days as a minimum, especially for now when we see that there's greater awareness and the stigma around talking about menstruation is reducing. More women, are coming up and talking about their experiences. And when they talk about the kinds of pain they go through, then we are left wondering as to, well, why have we waited so long? It's the stigma around this issue is finally breaking officially now because it's been recognized in legislation. For years, this has not been talked about in an open way. And what we are now finding out is that, some women go through excruciating symptoms of, menstruation, from PCOS to endometriosis, extreme pain, extreme pain. And the pain, we can't describe it. And unless you go through it, you won't understand what that is. So recognizing that as a special, unique thing that some women will need is to me, a step in the right direction. And as for abuse, which is the biggest concern, well, there will be some who will do it, but not everybody.
Any other question, members?
Sorry, Chair, can I just
Sure.
have a follow-up questions? When you're looking at that, and then we have had a discussion on discrimination in the workplace. So if you make an allocation, special allocation for women, and then how that would reflect on the men working in the same workplace, because men don't go through the cycle. How would you consider balancing that so that the probability of people saying, oh, this is discriminatory, that we only give women additional sick days without men being considered?
But that's it. It's not sick days. It's menstruation days. And women are the only ones that menstruate. So it's not discrimination. You see, the same way as maternity leave is only granted, to women, the same application is for menstruation. If you look at convention, CEDAW, for example, CEDAW says that any provisions put in place that accommodates women's reproductive needs, it's not discrimination. If men were going through similar, monthly cycles, then yes, yeah, what is the equivalent that would happen? So it's not discrimination, and we must not conflate what is provided as special needs for women. Finally we have recognition of that as discrimination at all. It's not. It's finally recognizing that women for centuries have been going through this, and it's finally being recognized. So you are removing oppression. And removing oppression, CEDAW defines that as not discrimination. And it must not be entertained at all, because to me, then we are, not looking at the issue in the right way. Because this is the reality, that only women go through this. And we still don't provide for things that only women go through. So it's not discrimination.
Thank you. I just have a last question before we close the session. MSME sector provides 60% of the workforce. And when you look at our size of the economy, it's around 5 billion. Otherwise, it's only 4 billion in terms of the revenue collected per year. There was a presentation from MSME sector, and they have raised their concern from practicality point of view. They're micro and small businesses, they employ women, and they are saying in relation to breastfeeding, that how do you expect us to provide those facilities for women to breastfeed? That's one question. And second question is, if something happens at the workplace to the baby, who will be held responsible? So these were the two major concerns raised by the MSME submission to the committee. And we would like to gather your views on it so that we can discuss this further to understand the implication of this provision on the economy and in particular MSME. Thank you.
Yes, thank you, Chair. That's a very important question. Whilst in the current draft of the bill, we welcome, the high fines and what should be put onto the employer's plate, for them to delivering for their employees. We recognize that. However, there still is scope for further, I would say, delineation of the different types of employers. Because you are right. There are, we can't just lump everybody into the business sector and say, oh, well, your fine is this and you need to provide everything. So to me, what makes a particular law or a policy fit for our purpose is that when it actually details, the different categories and then places allocations that would be suitable for that. What are the different types of employer accommodation in that way? But not to say that things like leave and all of that would be touched. I'm talking about in terms of the different workplaces. Say, for example, if it's a micro and small business employer, and they are using the value chain methodology of work, it's not the same as someone working in a factory or someone working in an office. So to me, if we were truly going to make, our employment laws applicable and useful, then we need to go into that kind of detailing, and which we have not had the opportunity for, and then it will be a lot clearer to see, well, if you are in a particular type of workplace that has employees in one building, then what needs to be provided for. That lack of clarity creates that ambiguity and the unsettled notions of, well, we all have to, provide the highest level of care, rather than recognizing, well, we are a particular type. To me, there's still scope to be a little bit more detailed, so that we do close the loopholes and we don't look at everybody in the same way, which at the moment the bill is looking at everyone, all the employers in the same way. Again, it does pose as a little bit unfair, because most of the micro and small business owners are women, and so how would they cater for it? That again, and I think that is an area that needs much more work in consultation with those business owners to see in practicality, well, what can they give without taking away the protections that the law should be providing. So in my opinion, that requires a lot more work, and we haven't done it, and we need to do that.
So you can understand the dilemma the committee is going through, because on the other, if you look at the rationale for bringing these changes to the Employment Act, through a bill is um, to grow the economy, to improve the productivity, and many other things are listed. And then when we go out into the committees, when the committee goes out to the employers or to workers in different places, like for example, the issue raised by a market vendor, a woman, and she says all this provision in the bill would simply mean I will not have a job. So it made us think as a committee, how do we deal with it? And that's why I asked you that question. And we would appreciate, from the committee's perspective, if you have anything else to tell us how we can deal with that provision. Please feel free to make a submission again, touching on those issues, so that the committee can consider and see how we can produce a bill which is not going to stifle economy, will protect women's rights, and also protect the employers. So it's a balancing act, and it's a hard one too. So we'll try our level best to do that. So in closing, I'd like to sincerely thank you for making your presentation and availing yourself this morning, and for answering our questions, giving insight into what your organization does, and also some of the ILO provisions that touched on women. And you've also made a written submission, I understand, which is with the Secretariat. We will have time to go over it. So thank you once again, and Vinaka Vakalevu. Dhanyavad.